right then. Let's get it up to 30s, probably.
Order.
Mm. Kevin, are we good to go?
Yes, we good.
Okay. All right then. Hello, everybody. Good afternoon. Thank you for joining us today in this part 2 of our virtual Just Up workshop series. Some of you may know, and I think I do see a few names here. You participated in the first part of this where we had a Zoom meeting with Mbak Atalia Sumarko for the basics of Just Up. And now as a follow-up to that, we are going to get to hear from a judge and a competitor of the Jessup talk about how oral pleadings are viewed from a judge's perspectives and scoring. And so, yeah, I'm just going to briefly introduce to you our speaker, Dr. Harry Elias, and our moderator, Tesalonika Shinta from Universitas Erlangga. Nah, Tessa is a Jessup competitor in 2018 and 2019. And as for Pak Hari, if you've been to the Jessup national rounds, he should be a very familiar face. I believe he's been judging the national rounds for a very long time. I don't know if you've coached a few teams as well, sir.
Yes, I have.
Yeah.
Including Tessa, actually, briefly.
Yeah, so before I pass this on to Pak Hari and Tessa, just a few things to note for the participants. Even though this is a webinar, we highly encourage you to be as interactive as possible. So if you have any questions, feel free to drop them down via the question and answer feature, or preferably, you can use the raise hand feature and our technical team can turn on your audio and you can ask your question directly to Pak Hari. So whichever one works for you, we'll be happy to entertain your questions. So I will just pass this on to Pak Hari.
Right. So are we on? We are indeed. So good afternoon, everyone. And thank you very much for joining us this afternoon. It's a Saturday afternoon. It's wonderful here in Bandung. You actually normally should be out or rather at home. If you're at home, you're probably, well, let me just get this right. So good. Right. This is about oral advocacy, and I've been asked this afternoon to join you just to share with you some of a judge's perspective of the oral rounds and how we actually mark and look at the way in which you moot during the competition. Now, I would say that there are 4 things that we're going to do. The first, of course, is just to give a quick introduction to what it is about. I'm going to look at the point scheme in detail. A lot of the teams have looked at the point scheme, but sometimes you don't really understand what the words mean. What does it mean in terms of performance, right? So you can see the word, understands the law. What does that actually mean? What are we looking for when we say we're looking for your understanding of the law? So we're going to look at the point scheme. Then I'm going to share with you the 10 commandments. Okay, these are my commandments, and as ISIL has pointed out, as Tiffany has said just now, I've coached many teams, and this is the way I coach. I require you to be prepared in a certain way before you rear up on your hind legs and moot in the competition. This will be followed, of course, by a Q&A, a question and answer. I actually personally don't like webinars. I much prefer Zoom meetings because then I get interactions and I can see your reactions directly on my screen and engage with you. but never mind. That's a Q&A. So you can use the Q&A, or you can stick your question in the chat, and the technical crew is going to look at the questions and it'll try to give you some insights in answering your questions. So let's start with the point scheme. So I'm going to share a different screen with you at the moment. And this screen, let's see where it is. As always, I can't find it yet. Um, this is the point scheme. Give me a moment. The point scheme, yes. So lots of people have seen the point scheme. And just give me a thumbs up. Tessa, can you see the point scheme, the marking scheme? Thank you. Lots of people can see this, have seen this before. And in practice, and as you are preparing for the competition, you are looking at this particular rubric. Now, what does the rubric actually mean to a judge? So I'm going to take some time now. We're going to take about 6 or 7 minutes to look at each of these elements separately. And then I'm going to try to give you some insights. Now, as I'm giving you insights, in my mind, listen very carefully, in my mind, I'm going to address different things to different groups. And there are 2 groups I'm thinking about. The first group are teams which have a long experience and history of mooting. And I'm going to tell you how to get the 26 to 30, the top scores in each of these elements. Then I'm also not going to leave everyone else behind. I'm going to talk to the teams who feel they are middling teams. So you don't really have a history of mooting. This might be the 2nd or 3rd year that your university has sent a team to the competition. And I'm going to try to give you some practical things that you can look at and things that you can do so that you can then move yourself up the spectrum of scores so that you move to the next band. All right, so just keep that in mind. Let's go to the first one, which is the knowledge of law. Now, if you look at the knowledge of the law, obviously the maximum score is 30. It's a 30 out of 100, and that's 1/3 of what the overall score is. Now, you see there, and the type font might be a little small, so I'll read it out to you. Accurately states and applies rules of law. Okay, so you need to know the law. That seems obvious. What does that actually mean? What is the meaning of know the law? Now, there are 2 elements in knowing the law. Now, the first element in knowing the law is actually understanding public international law in general. You need to have the first big picture idea of things like customary international law, the ICJ statute, what the powers of the court are, what the sources of law are. So don't jump into preparation until you are clear about the foundations and the basics of public international law. Now, this morning, the new compromise is out. Correct, Tessa? I saw that on the net. And obviously, it's about the a pandemic and the shooting down of an aeroplane. I mean, you can't be less creative than that. Had to be about some viral infection pandemic across the world. But before you even go there, before you even open the compromise and start pulling it to pieces, please know the basic law. And I'm addressing this to the middling groups. I have heard strange submissions on what basic law is. Like, for example, a question that's often asked by judges would be, so are we bound by that case? You know, that's a question that's going to be asked. You must know the correct answer. And you must understand the foundations of the way in which the framework, the whole framework of public international law works. So that's one element I would definitely say to the middle teams. Before you even go to the compromise, look at basic public international law. You need to have a good grounding. And if you are at a loss of what kind of questions are being asked, for heaven's sake, just ask your friends from the other universities. By now, the more established universities, the ones who've done so many moots, would already have a long list of about 20 questions that are all always asked about general principles. And you can take that list and then get clear answers of that. So we want to see that. Now, the next thing that's on that knowledge of the law section is the knowledge of cited cases. Now, uh, they're very kind, and I don't know why they do it, but they give you all these basic materials. You need to read the basic materials. The answers are all there, actually. Okay, go there, and then you look for them. So that is for the average teams. Now, for the good teams, you can't just rely on that. You need to go beyond. And there's nothing more impressive for a judge to listen to you moot and then come up with a case that's not even in the bench memo. And then we go, wow, this team is really fantastic. Not only do they know as much as I do, because most judges will only read the bench memo, but this person has gone beyond that. They found something that is startling. So for the good teams, I say to you, make sure you have something that's startling, something that no one else knows, so that you can come to court and with that gem, somehow weasel it into your submission, into your oral submission, and impress us, because it impresses us when we hear something new and novel. So that's what I would say to the good teams. Um, Strong legal arguments, everybody has strong legal arguments. Distinguishing unfavorable authorities. Yeah, this is one thing that I find lacking in my experience in judging teams. You seem to hit a roadblock whenever there is a case that doesn't go in your favor. And you really must be able to distinguish cases on the facts, or distinguish cases on the time period that it was decided. Obviously, the overriding principle is that no cases bind the parties anyway. Cases only bind the parties in that case. It's not binding. So that is what we're looking for when we say knowledge of the law. Then we have the next category, which is basically questions and answers, right? And one thing I find most irritating is when one of the counsels says to me, repeats the whole question again to me. It's like, oh, please don't do that. I want an answer. Okay, I want an answer. And I'll talk about a little more about that when we do the rest of the slideshow. So knowledge of the facts. Now look at knowledge of the facts. First of all, it says know the facts and fairly and accurately interprets the facts. So here's a nugget for all of you. Listen very carefully. Nothing in the compromise or the agreed facts, well, it used to be a compromise, now it's the agreed facts. Nothing in that document is superfluous. Every single sentence in the compromise goes into one of the four issues. There's nothing extra. Now, what we are looking for is how you interpret the facts. So here's my advice for middling teams, the average teams. As you go through the compromise, remember nothing is extra. Every fact that is there needs to be slotted into one of the four different issues. For the other side, for the good teams, what we want to see is how you interpret the facts, because the facts can work both ways. They can be helpful to the appellant, the applicant, could be helpful to the respondent. And what we want to see is how you tailor the facts to suit your case theory. Okay. And that should be something we hear throughout your oral advocacy and your presentation during your 22 minutes. Now, style, pause, and demeanor. This is for good teams. The overriding principle is this, and this I will tell you: stop acting like a law student. Time and time again, I see mutis come and they act like law students. They're so scared, and they're almost subservient. No, what you have to do is, this is a role play. Remember, it's a competition. It's all make believe. And what you need to believe is that you are a lawyer of 20 years experience representing a country in the International Court of Justice. And that's the kind of professionalism that we want to hear, really. Stop acting like a law student talking to your lecturer, for God's sake. I'll give you a little tip just to make you feel a little better. When you go for the first moot, in the morning session of the day one, the open rounds, I tell you, you probably, or not you probably, you definitely know more than the average judge that is judging you. Okay? I'm very sad to say that many of my colleagues would go to judge these things, and they may not even have read the compromise. Really, that's why you have a cold bench on the first morning. It's not because people are sleepy, it's just that no one's actually read the compromise. So you are actually the expert in the room. You know more than the judges. Trust me, for the first morning 8 a.m. mood. Okay, so bear that in mind when you go and do the morning session. You're smarter and you know more than the whole panel of judges. Okay, of course, not all judges. Some judges I know prepare a lot. Okay, and we go in the morning, and then at 8 o'clock, the team comes out and says, "Oh my God, the judge just whacked me. There's nothing to say. How did he come up with all those questions? We didn't even think of those questions." Okay, so think of that: style, poise, demeanor. And the last one is organization and time management. That's a small point. That's just 10 points. But you'll be shocked at how many judges only give 6 or 10. Why? Because what you do not realize is that you actually are in the driver's seat. To get a high score, you can answer questions, but when your time is up for that particular portion of your submissions, you must have a clear strategy to say, "Thank you, Your Excellency. That is all the time I have for that issue, and I have one further issue, and I would like, with your permission, to move to my next point." You really have to do that. You have to remember that you're in the driver's seat and that the time is dictated by you. Do not let the head judge or the big mouth judge take over your time. Control your time. You are in the driver's seat. So that's all I have to say about this rubric. Okay, and if you have questions, just stick them into the Q&A and we'll come back to that later. Let's now go back to my PowerPoint, and I hope this works. It should. Right. Now, so we've looked at the criteria, and we're now going to move to the next part of the presentation. And of course, it is the 10 commandments. So these are my commandments. Do them and you will do well. Number 1, prepare, prepare, prepare. There is no substitute for preparation. If you have decided to take part in the Jessup Moods, you have also decided not to enjoy your Christmas break. There is no Christmas dinner for you. You will be miserable for the whole of December and January. It comes with the territory. It's a cost-benefit analysis. Once you've decided, I'm going to take part and I really want to take part in this properly and I want to do well and I don't want to malu myself in front of my school, right? Right. It's a commitment and you need that time to prepare. There is no such thing as last minute preparation. And I'm sure that through the series, you've had a lot of advice as to how to prepare both the written memorials as well as the oral advocacy. Know the facts. It's shocking how many people don't even have a timeline of the facts. Make sure that before you start, write a timeline. One of the things I make my teams do is make a timeline, because there is nothing more impressive to a judge when I say, did this happen then? And the reply is, well, that was on the 7th of September, Your Excellency. However, what we're talking about is the note that was sent on the 11th of September, 4 days later. That is impressive. And that's what we're looking for when we want to see you get the high scores for the knowledge of the facts. Okay. Now, one challenge I would give to all teams, whether you're a middle team or a advanced team, is always ask yourself, why should I win? Why? Because if you cannot answer that question in 50 words or less, then you don't know your case. You haven't distilled your case to the most important submission that you need to make. Now, why do you need this? So I'll repeat the question again. In 50 words or less, why should your client win? Okay, in 50 words or less, why should your client win? You need to choose your words very carefully, and you need to read this over and over again. And I'll say why you need to do this. Apart from the preparation and the understanding of the essence of your case, what is important is that this is what you go to, this is your go-to place whenever you're stuck. So the judge, let's say you're a very good team and the judge says, okay, I'm going to take them through, I'm going to go for a gym workout with them, right? An intellectual workout. And I start asking questions and we peel the onion and we go and we ask and we ask. Now, at the end of the day, when you're really stuck, that's when your 50-word or less answer comes in. Okay, it's like your saving grace. Say, well, be that as it may, Your Excellency. However, this court must be mindful that blah, 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 blah. And that's your 50 words saving the lifeboat that you have. So always ask yourself, why should I win? And you need to have this clearly done before 7 days, about a week before you actually stand up and argue the case at the moots. Commandment number 2, please just be yourself. It's credibility, okay? If you go there and you're distracting, I've seen people sweat a lot. I've seen people with very long fake eyelashes at the competition, and it's just strange. It's distracting. Just lawyers. There are certain ways that lawyers, the demeanor, that's the way you talk, it's the way you move, the way you use your hands. So look at examples, because there are good examples and there are bad examples. And if you don't know what to do, put your damn hands on the table. If you don't know what to do, just take your hands, put them on the table and moot. That is the least you can do. I always teach people how to do the duga. I can't show you how to stand when you do the duga, because I'm actually in shorts below the waist. But you want to stand and do the duga, which is a very nice presentation style, a standing style. So all my mooters, we like to see the duga. You'll see it. QCs in England would do it. They would stand in a certain way and they would move. If you don't know what to do with your hands, clasp your hands, put there. If you don't know what to do, put them on your table, because there's nothing worse than distracting movements from yourself. And please don't try to be someone you're not. Start with your own personality. Unless your personality is horrible, okay, then you have to reinvent yourself, and you need to have that conversation with your coach. But generally, most people are all right. You're all good mooters. You start being good and you want to get better. And you want to establish that credibility with your face, the things you say. And credibility also has the other element, which is basically don't try, don't try BS with the court. Okay? It might work while you're practicing with your friends, but some of the judges are quite smart and we can see through it. And a nasty judge might actually take you up on it and say, I don't think so, blah, 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 blah. I mean, I'll just give you a very quick, two quick examples. I think it was maybe 10 years ago that someone quoted an ICC case, International Criminal Court, and he said this case stood for the proposition, blah, 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 blah. And the judge said, yes, I was the prosecutor actually for that case, and I don't think we submitted that. So, end of story. Another person, I think this was about 4 or 5 years ago, talking about law of the sea, when, well, in the case of Guyana and Suriname, blah, 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 blah. And I said, well, actually, I was the counsel in that case, and that was not what we submitted. And then another moment, and too many of these moments don't really build your credibility. So you might get away with it in practice with your friends. At the higher levels, especially if you're going for you're in the semifinals, you're one of the last four, one of the top 8 teams, keep the BS out. If you don't know the answer, or you don't have a good answer, be honest and say, well, this is an uphill battle, Your Excellency. This is really a point that is bothering us, but be that as it may, our submissions are still that, blah, 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 blah. Okay? Don't use the BS because it loses you credibility. You want to keep yourself in the good books of the judges. The third commandment, be formal, be respectful, sorry. Okay, I've seen people get so angry with the bench. No, actually not angry with me. They think I'm attacking them. I'm actually trying to help them. And you're like, and crying, and that's really unnecessary. Okay, it's all for fun. It's a role play. It's games, fun and games. It's a sport. Enjoy it. Okay, but be respectful at all times, right? I've seen some teams be very rude about the other side. And I'd like to clarify one thing that seems it's strange to me. Okay, the term my learned friend, right? Which is how 90% of the world addresses the opposing party's counsel, is not being sarcastic. There's this rumor going around in Indonesia that when you say, my learned friend, it's supposed to be sarcasm. It's not. It is the accepted, normal way of addressing counsel from the other side. So just go, my learned friend. It's very respectful, okay? I know which university started this funny rumor that it was sarcastic, but I will not name that university in Jakarta. Right. Next slide. Use your time wisely. As I said, you are in the driver's seat. Okay? Always have your framework. Now, I'm a bit strange. I don't bring files up when I used to moot. I brought one piece of paper, literally. Okay? And I did this in practice as well. I mean, I've had the pleasure and honor of arguing the ICJ, the Supreme Court. And basically, I always just bring one piece of paper with everything I want. And it's nothing else on it because I know my case by then. So you need to set your framework. And judges are very quick. We listen to it and we know whether you have a framework. Because if you're going all over the place, right, we know that actually you don't really know what order of things you are talking about. And remember, it's strongest argument first. Don't waste your time following your memorial. It's strongest argument. Hit us with the strongest argument. You only need to win with one argument, not three. The rest are already, we've read it, hopefully. We've read your other arguments, but what you want to do is to spend that 22 minutes or the 25 minutes with us on very strong grounds. and impress us with your strongest argument first. Another thing that I would urge you to do, um, middle teams, listen to me, the average teams. A lot of you feel you need to fill up that 25 or 22 minutes. Is it 22? Yep, 22 minutes. You want to fill up that 22 minutes. So you think, I'm going to spend 5 minutes talking about the facts. Don't waste your time, right? We are not interested in the facts. We know the facts. We've heard it so many times already. Go straight to your arguments. At most, you want to spend maybe 30 seconds. Well, this is a case about blah 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 blah, and that's it. Now the issues here are blah 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 blah, and then you go on from there. Now for the good teams who are looking to score very high on this, tell us how the facts should be interpreted. Don't tell us what the facts are. Tell us how they should be interpreted. Okay? And that should not take more than 1 minute. Talk about the facts for a minute and then just go straight into your arguments because we want to hear arguments from the very good teams. Okay? The next slide goes commandment number 5, pay attention to us. Time and time again, you see councils just there as if they're there alone and they're doing it. Now, what's made it more difficult, especially about body language, is I know that it's going to be a virtual competition. So a lot of things that I have said or the way in which we've been mooting over the last, the first moot, by the way, the first moot that I took part in as a student was in 1984. Okay, I don't know how many of you were born in 1984, but but that was my first moot. And let me say that this is the first time it's going to be virtual. So a lot of the things that I have done or things that I have taught other people to do as a coach are not going to be particularly relevant, especially in body language. And I'm interested to see how this develops. What would be a good mooting style? What would be good body language? How do we engage a judge who's really not sitting in front of us? Here we are wearing our black tops, white and a nice black tie, in our football shorts, maybe probably barefooted. And here we are talking about international law, and what body language would suit that online environment is really something I hope to see and explore this year. The questions. Questions are not there to make it difficult for you. The assessment rubric, the point scheme, requires us to ask you questions. If we're nice, we'll ask you banal, boring questions. If it's really in the morning and no one's read, if your bench hasn't read the bench memo, there may be no questions. Suddenly you're like 22 minutes. And if there are no questions, may I resume my seat? Yes. Okay, that is a bad mood. That is a bad mood because one of the things we need to give you points for is really about how you answer questions. And this is how you should answer questions. It's either yes, no, depends, or I don't know. Okay? The first thing that has to come out of your mouth must be yes, Your Excellency. We agree, Your Excellency. And then explain your answer. Time and time again, I hear teams and councils giving me this long story about this case and that case. And then I go, no. Do you agree? Well, I still don't understand what your answer is. Do you agree or not agree with my statement? You haven't answered the question. So always answer the question and then elaborate. Okay? Some people say this is a good practice, some say no. Okay? I think it depends. You don't say this for every question that is asked. But if a question is very convoluted, especially if the judge himself is bad at framing the questions, then in your long tirade of an answer, at the end of the day, you want to ask the judge, Now, if you feel, you look at the judge and you feel you haven't answered his question, he's still like, don't ask this, because he'll say, no, you haven't. What if he says, no, Tessa, you haven't answered my question? Then you're in trouble. But if you feel like, yes, this is a 10 point, and you want to consolidate to remind the other two judges, hey, I answered the question really well. So you ask the judge and say, uh, Dr. Elias or President, Mr. President, have I addressed your honest concerns on this particular issue? And then I'll be forced to say, yep, quite well. And then the left and the right of me who's listening to it say, oh, okay, she answered questions well. And that's the impression you need to leave with the judges as you're answering questions. Okay. So for the middle teams, questions are there to give you points. Look at it as opportunities to show off how much you know. Okay, don't look at it as, oh, so difficult. Why is he asking me so many questions? I'll just make one quick comment. When I was a judge initially at a competition, and no one knew me, how difficult I could be as a judge. Sometimes I'm very honest here. Um, I would sit as a junior member, and then people would present their cases, and then I'd ask my first question, and I'd ask my second question, and then when they realized that I was a very active judge, then you can see them all take out their program and flip, 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 and look for who I am. It's so strange, okay? But we are there to ask questions because that's how we tell the difference between a very good team and a team that's not very good. That's how we actually do our assessments. And once you've finished, return as quickly as possible to your presentation. Okay? A lot of times there's this funny, awkward 2 seconds. So judge asks you, you answer, and then I look at you, you look at me, and then we look at each other, and then I start. No, a really good, smooth team knows where they left off and goes straight back into where they were interrupted with the question. Okay, and that's really, really excellent. And you can do that. This is for the good teams. You do that because you know your case so well. So don't have a rehearsed speech in your mind. Know your case. Go there and just tell us, have a conversation with us and tell us what your case is about. We're very interested to hear what the case is about. Now, making concessions. Concede when you have to. A lot of times, one of the things I always do when I know instinctively this is a good team, I push them into a corner and then I want to see whether they concede. Okay? You can make a concession, but always remind the court that the concession does not alter your submissions. Well, be that as it may, even if your excellency is not with me on that point, I would still argue that blah, 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 blah. And that's the kind of things we like to hear, okay? That you can know when and how to make a concession effectively, right? So learn that skill. Always end on a high. You need to have a strong conclusion. And this is again where you have that 50-word summary. Why should the applicant succeed? In the final analysis, Your Excellency, we have argued that, and then your 50 words come out. Always end on a high, okay? Remember to restate your relief. If you have time, do it properly. But when you do it, one important point, if you have the time, for example, to state your relief, please also do the background as to whether the court has the jurisdiction to make and the powers to make those orders. Okay, I've seen people just read, and the applicants pray that the court will blah, 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 blah. And then I say, well, do we have the power to make those orders? And then the teams, Okay, so make sure that that's clear. Right, Commandment 9, we're almost at the end. I'm going to let you go soon. The rebuttal and the surrebuttal. KISS stands for keep it simple, stupid, okay? Too many teams spend the rebuttal telling me all kinds of things and No, keep it very simple. All right. Don't repeat your arguments. The rebuttal is to rebut the other side's arguments. You may have already rebutted. If you have already rebutted, just stand up and say we have no rebuttal. We feel that our submissions have more than adequately addressed the respondent's case. And shut up and sit down. Okay? Don't feel you need a rebuttal, okay? Because we can see where people are struggling to make rebuttals, and this is so badly done. Uh, and if you're doing surrebuttal, the same thing, right? Keep it simple, stupid, number them. So this is what we like to hear. So you could say, for example, well, in rebuttal, we have three arguments raised by the respondents. First, second, and third. Sit down. The sub-rebuttal starts, and we like to hear, this is our sub-rebuttal, Your Excellency. First, my learned friends have argued. We argue that. Second, my learned friends have argued. We argued that. Third, my learned friends have argued. We argued that. And shut up and sit down. Now, I've even seen some teams insist on a surrebuttal where there was no rebuttal. It's strange. But it's obvious that these teams, please, middle teams, know that just because you don't make a rebuttal doesn't make you bad, doesn't lose you points. And same for the sub-rebuttal. Use it if you need it. If you don't need it, don't abuse it. Okay, don't use it if you don't need it. And the last commandment is really just practice, practice, practice. There is no substitute for practice. Now, the question is, how do you practice? Now, I like to start and just giving you some practical advice, especially for the middle teams. Don't immediately come into the room and practice. There needs to be a warm-up time. So one of the strategies I use is to do what I call corner work, and I make the four mooters go to a corner of the room, and they stand against facing the wall, and they moot and they listen to themselves. That's the warm-up, and then they come together and then they moot. I don't like long moots. And one important thing about practice, and this I'll share with you, there's a tendency for teams to try to incorporate every one of the people's comments and suggestions. So, for example, if you have access to a lot of seniors, let's say 10 seniors are helping you during the practice, and you go and you listen to the first senior and he says, do this and this. Then the second senior says this and this, and it goes down the line for all 10. You find that at the end of all these practices, there are so many suggestions, many of which are conflicting, and then you don't know what to do. What you need to do is really to assess first, is this suggestion coming from a person who is helpful, and whether he has the experience of litigation. Now, it's very hard to find a litigation lawyer or someone who's practicing arbitration, someone who's actually advocating every day, appearing in court, and for them to be your coach. So don't listen to all these corporate lawyers telling you how to moot, how to argue, how to advocate, because actually they don't really know. Okay, so you don't have to take every single practice and say, well, this senior said this, we should do this. This senior says this should do this, because it's just self-destructive. You have over too many cooks. You need to really decide who you want to listen to and who you don't want to listen to. Of course, you want to be polite. So by all means, you want to listen, you want to go to their office, smile at them, let them be your practice judge, and you practice it. But always remember that there are different qualities of suggestions. So as you practice, keep that in mind at all times, right? So my last slide, I think, is a question and answer. I am at the end of my PowerPoint. So I'm going to leave it now to Tessa to deal with the questions. I hope that you are paying attention, and I hope that both types of teams would benefit and take away some key takeaways from the session this afternoon. I haven't wasted your Saturday afternoon, I hope. Go ahead, Tessa.
Thank you, Hari. Thank you, Dr. Hari, for that very informative slideshow. So, there is actually already one question, so maybe I can just ask it directly. Um, it's from an anonymous attendee, but it says, "Dear Dr. Harry, what is the proper answer? What is the proper way to answer when we do not know what the answer is?" So I think
Well,
talking about
okay,
knowledge of the facts or law, I think, yeah.
right. I have a question actually for the person who asked the question. Is it something you don't know about the facts, or is it that your imagination can't at the spur of the moment pull a question down? I suppose I have to answer both ways because this is not a Zoom meeting.
Right,
Right.
right.
All right. Okay. So if it's a fact you don't know, say, give me a moment and go and check it.
Right.
Okay. Go and check it. Just say, give me a moment, Your Excellency, let me check that. And then, with great embarrassment and shame, look through your material and find the answer for the judge. Now, if it's a question about the interpretation of a law, or for example, if the judge actually says, are you familiar with the case of A versus C decided in arbitration? Okay, so you simply be honest. If you don't know, don't bluff. Because if you bluff, we will call your bluff as a judge. Okay, so you just say, I'm not familiar with great respect, Your Excellency. Be very, tunduk tunduk, and say, I'm very sorry, Your Excellency. I'm not acquainted with the facts of the case, and I have not come across this particular case. Would Your Excellency like to tell me briefly what the case held, and perhaps I would be able to then respond to the case. So you might want to say that. But the rule is, and the advice from me is, really don't try to bluff. Because if it's a case, you see what happens is that you get the bench memo, right? We get the bench memo. And usually after the first session at 8 a.m., then people become serious. They start reading it. Plus, after the end of the first 8 o'clock session, they've already heard the more well prepared judges uh, ask the questions. So they sort of get a feel of which direction they're going, and they can zoom in on the bench memo and know what's important. Now, on your side, if especially if you're a middle team, I mean, I'm not talking about the advanced team. Advanced teams know how it's done. The middle team, after the first session, you need to have someone write all the questions down, because these are the same questions that are going to be asked over and over again in second, third, fourth, fifth mood. And you can see the development of the questions. If there's a question you don't know, Google it. At least Google it. If you have a teacher there, ask the PIL teacher, what's the answer? I don't know the answer. I've never heard of this case. What's this case about? And know that it's going to be asked again. So you've lost some points. Let's not be shy about it. You have lost some points simply because you were not able to respond intelligently to one aspect of the law. But don't let that happen again. Make sure that in the second time, if the judge asks you the questions, especially if you're going to make the same argument again, right? Then the judge says, but what about this case? And then you can respond more fully rather than say, I'm unfamiliar with that opposing case. Okay, so I hope I've answered that question to the anonymous questioner. Now I see. Ooh, wow. Okay, I can
Yes.
see the questions.
Yes, there's quite a few
And they're
questions.
coming. Oh my
They're coming
goodness.
in, yeah. So I guess one from Mr. Ivan Gautama. Uh, a pleasure to attend your Pleading 101 presentation today. You mentioned that judges are well impressed when the counsels can go beyond the bench memo. Can you perhaps give us a little picture on what the bench memo usually contains? Is it limited to the contents of the first and second batch?
Okay, they're not limited. Okay, they are longer than the compromise, obviously, and they clearly say what are the expected arguments from the applicant, and the applicants. So there'll be words like the applicants are expected to argue that, and then they have the cases, the specific law or the treaty, the specific clauses, and that's what you expect. So when I say to go beyond, is when you come up with something novel, or you come up with a case that the person who wrote the bench memo didn't even think about that is relevant. Now that is impressive, as Tessa will tell you, right?
Helen Hotel, sir. I still remember.
I can't remember the name of the case. Well done. There's another question. Is it?
Yes. Yes. So I think it talks about how we're supposed to satisfy the judges in question and answer. So judges often explain post round that the questions signal judges' interest in an argument. How can oralists gauge judges' satisfactions in their arguments during a cold bench or a hot bench? And especially when it's evident then that the judges are not very keen or they don't like the arguments brought forth by the counsels.
Well, if it's not a if you feel that you're not getting anywhere with the judge, dump the argument. That's what I do. I can just tell you, it's very impressive when you can say, "Well, Your Excellency, you seem unimpressed by the line of cases. Perhaps I can persuade you with a different line of arguments." Then you go to another secondary argument. Now, I'll share with you something that I share with the teams that I've coached in Indonesia and abroad. It's called peeling the onion. Okay, peeling the onion. And if you know, you peel the onion, then there's something underneath, and then you peel the onion, and it keeps going until you get nothing left. Uh, when I say peel the onion, I mean when you're thinking about your arguments, you should have one person who's called the peeler of the onion. And his job is just to ask one question: why? Why? And so you come up with an argument, and let's say, Judge Tessa, I argue this. Then the peeler of the onion goes, so why? And then you have to go there again. And after I give that answer, you go, so why? Now, once you peel the onions at 3 different layers, that is when you know you've thoroughly finished the arguments. So usually what happens when the judge is unimpressed is he's peeled the onion one layer and you haven't got your comeback answer. You haven't been able to get to the essence of your argument. So when you are practicing, have one person who's listening, don't care about your answer. His job is very simple. So, why? Or in Indonesian, jadi? So what? And that's all that this person keeps asking you at practice. Now, you will find after a while that as you're going through your arguments, if you come to a judge who's not buying your arguments, you're arguing, and it's because you haven't peeled the onion. If you're used to somebody keep asking you why, so what, jadi, terus, so what, you find that you can very, very efficiently deal with these sort of questions from these sort of judges. Okay. Now the next thing I will tell you is that you don't have to please all judges. Okay, some judges just look uninterested, but they're actually very interested. Some of them are tired. They just came from work. It's Saturday afternoon. They'd rather be home. And what are you making me go and listen to this competition? So it's lots of motivations. Don't look at them. I agree. Observe, look at what they're writing, listen to them, and you very quickly be able to tell whether they're following your arguments. But in practice, what you want to do during your practice is to be able to peel the onion. so that you can come back. It's the comeback. And worst comes to worst, worst case scenario, they don't buy your argument, move to another argument. Don't beat a dead horse, because it's probably in the bench memo itself. It might say the respondents may argue abcd, right? However, abcd cannot lead to this conclusion. So the bench memo itself may tell the judges that there's no hope in your argument. So at that point of time, we know it's going to be unimpressive. That's the time to make the concession. That's the time when we are testing you to see, well, I concede. That's the state of the law, but these are still our submissions. Let me move to another argument. So I hope I've answered that particular question, given you some tips on how to deal with that situation. Tessa, back to you.
Yes. We have also a question. When judges are not allowing counsels to proceed to the next issue, because perhaps we haven't peeled the onion, as you said, despite the existing time limit, how should counsels proceed without losing points for time management? This assuming, for example, also if we have layers to the argument and uh, apparently the judges are not convinced with the first layer, so we couldn't move on to the second or third.
Well, know that, well, what you want to remind is, so the judge takes all his time with the first issue, right? And
Right.
this happens very often.
Mhm.
And then you have your second issue, which you can't do anything about. And suddenly you look at your watch and you have like 5 minutes more and you haven't even started. I think that at that point of time, to get the points for the time management, you have to tell the judge in no uncertain terms. And you could perhaps say, if I could suggest, Your Excellency, we've spent far too much time on issue one. I note that I only have 5 minutes more with issue two. So, with your permission, I will go to issue two, but I will only be able to deal with the key arguments and the brief outline of my arguments because of the time management issue. So deal with it. Tell the judge, and you get points for that, because it's not that you are not managing your time. You're trying to manage the time, but one of these difficult judges just won't let you go on one of the issues. And the other two judges will listen to you say that, and they will not mark you down. I wouldn't mark you down because you're well aware of the time management. And this other judge is just being difficult, just doesn't want to let go of a point. So you're not going to lose points. But what you shouldn't do is to just let it go on and on and on without saying and addressing the issue of your time. If you argue a case, let's say in the Supreme Court of the United States of America, you have a time limit. Okay, if you do an appeal at at the circuit court, you have 12 minutes. The brief is 5,000 words long. You have 100 cases to get through, and you have 12 minutes, and they literally say, sit down, sit down. So you really have a short time. And one of the things we want to be able to see is you being able to distill all of your arguments and to effectively communicate those arguments persuasively to us over that 22 minutes. Okay, so deal with it. Don't just be quiet about it, so that we can give you the points, because you're trying to manage the time. Okay, Tessa, any other questions?
I'm sorry, Dr. Harry and Tessa, can we do the one last question in the question and answer box and close things there?
Sure.
Yeah, of course. The last question is actually about making strategical concessions. So, what particular issues should we, as councils, be concede about to the bench?
Well, all that you're conceding is, I concede that there may be a different point of view.
Right.
I concede that Your Excellency may not agree, but those are my submissions. You can't change your submissions, right? You're not going to change your submissions halfway through the arguments. So, you know, you can concede that there's another point of view. I concede that that may be one type of reading of that case. The facts could conceivably draw you to that conclusion that Your Excellency is talking about. However, we stand by our submissions that this should be the proper reading of the law. This is what the law says, this is what the facts support. This is the case theory that is supported by the facts. So, in that sense, that's what I mean by conceding. You never concede that I am wrong. You concede that there is a different interpretation of the law, a different interpretation of the facts, but those are your submissions. Because at the end of the day, in real life, I'm talking about in real life, not in moot court, just a little bit out. Your job is to persuade the court. The court's job is to make the decision. You can't make that decision for them. So you just put your best foot forward and you say, these are my submissions. It's an uphill task. I mean, we all know that there are good cases for the applicant, good cases for the respondent. If you by luck of the draw, you get a hard, tough case that's not in your favor, what can you say? This is as far as I can take the submissions, Your Excellencies, right? But these are my submissions, and it is for Your Excellency to make that determination. However, we would repeat that, repeat your 50-word argument again. Okay, Tessa, back to you.
All right, thank you very much, Dr. Harry. Now I want to give it back to Isil. Um,
Thank you, Dr. Harry and Tessa. That is all the time we have for today's session, and a very insightful one at that. I hope we will be able to give more opportunities to hear from people like or from Dr. Harry Elias himself. So I would like to very briefly thank our speakers one more time. Dr. Harry Elias, for your perspective, both as a professional and as a seasoned judge. It's definitely much more than what we usually get in the 5 to 10 minutes when we get to hear your feedback in national. Yes. And thank you also for Tessa for your perspective as a seasoned and decorated mooter. Thank you for the participants for tuning in. And I would remind everybody that there is the second half of this program. Tomorrow, we will be talking about memorial drafting from a judge's perspective. And we will be talking with Mbak Hana Askia as well as Yogi Bratajaya from Universitas Pajajaran. So stay tuned for that. Once again, thank you, everybody, and have a good Saturday.
Bye, everyone.
Thank you very much.
Thank you, Tessa. That was very fun. Fantastic.
Yeah, very fun.
Are we off yet? No, we're still live on YouTube.